I call this meeting of the House Commerce Committee to order. There is a quorum present. May I have a motion to approve the minutes for February 28th, 2024?
So, Madam Chair, I was going to say, I'll keep you moving along. Move the
Very
minutes.
good. Representative Liebling moves approval for the minutes for February 28th. Any discussion, members? All right. Hearing none. Those in favor, please say aye.
Aye.
Any opposed? All right. The motion prevails, and the minutes for February 28th, 2024 are approved. So members and members of the public, in an effort to complete our agenda today, all discussion and testimony on House File 4100 will cease at 2:10 sharp to accommodate for other bills on the agenda. This bill is being laid over, and testimony and discussion will continue when the bill is before us again. We would ask that members, staff, and members of the public limit their use of Wi-Fi during this first hearing to ensure that our Zoom testifier is able to come through on the streaming. If members of the public could stay very quiet as well so that we're able to hear the testifier. Thank you for that. So the first bill on our agenda today is House File 4400. Chair Stephenson, would you like to move your bill?
Thank you, Madam Chair. I'll move House File 4400 be re-referred to the Judiciary, Finance, and Civil Law Committee.
Chair Stephenson moves that House File 4400 be re-referred to the Judiciary, Finance, and Civil Law Committee. To your bill.
Thank you, Madam Chair, members of the committee. House File 4400 results from a report produced by the Attorney General's office at our direction related to social media. Social media is having massive impacts on our society, on our children, and particularly on our children's mental health, which has been a topic of great concern to members from both sides of the aisle and a subject of many hearings in this committee over the last several years. House File 4400 does a number of things in order to put some guardrails and some regulation on a, to this point, almost completely unregulated, massively important sector of our economy. I do have a testifier today who I think can explain the particulars of what's in this bill, who was a key participant in the Attorney General's report that this bill is based off of. And in the interest of time, I'll turn over to him, but I'll be happy to answer questions when the time is appropriate.
Thank you, Mr. Chair. So we'll call Dr. Ravi Iyer, USC Marshal. You can introduce yourself and begin your testimony.
Sure. Hi, everyone. My name is Ravi Iyer. I'm the Managing Director of the University of Southern California Marshall School's Neely Center. And before this time, I actually worked for about 4.5 years at Facebook on some of these issues. So I'm going to share a quick presentation that illustrates some of the issues that this bill is designed to address. And so the goal
Dr.
here—
Iyer, just a brief moment. Sorry to interrupt. This presentation is available online because it's not being telecast in the room at this moment. Thank you. Proceed.
It's not being telecast in the room? Is that what you're saying?
It is, members are able to see the presentation, but members of the public are not able to see the presentation, but it is available online.
Thank you. So the goal of the bill is to prevent unwanted experiences by users. And so HF 4400 mandates that platforms follow the user's explicit desires rather than assuming that the things that people spend time on are truly the things that they want. So I'd like to go over 4 main features of the bill. It mandates privacy by default, responsible amplification, sensible rate limits, and not encouraging greater usage for children. And then it also has some transparency provisions that help us illuminate future risk where platforms might be engaging in design choices that encourage unwanted experiences for users. So I'll go through each in turn, talk about the problem, and then the solution that the bill proposes. So first, privacy by default. There are many instances of manipulation and fraud that begin with unwanted contact from strangers. The quote in green is one of many that the Attorney General's office has received from users who are just more public than they want to be on these platforms. You sign up for these platforms, you don't realize that anyone in the world, you sign up to talk to your friends, and you don't realize that anyone in the world may be able to contact you. Oftentimes, kids don't realize that an attractive stranger might actually not be the person they say they are. They might just be excited. That's just part of being a kid, right? And it's not most kids that are reporting these kinds of experiences, but it's a significant minority. So in one study in Utah, 26% of adolescents reported getting involved in unwanted conversations. In internal research from Meta, 1 in 8 users under the age of 16 reported unwanted sexual advances on Instagram. And sometimes these things, don't lead anywhere, but sometimes they can really have grave consequences. So the FBI recently released a report warning people about sextortion, often targeted at young boys. They document over 12,000 cases in the past few years. Unfortunately, in about 20 of these cases, youth actually committed suicide. And these are just cases that, rose to the level of seriousness. They got reported to the FBI. Obviously, youth are not going to be, they're going to be somewhat embarrassed about reporting these cases. So our solution to these kinds of issues is just mandating that messages cannot be sent from outside of a user's existing extended network. You sign up for this platform, you can add a few friends. The friends of those friends can contact you and befriend you, but it's not just anyone in the world can all of a sudden discover you and start asking to be your friend. We also mandate that your account and your content are not publicly visible. You can't take your face, for example, and put it into like an AI model. We're concerned about generative AI and non-consensual sexual imagery. So people won't be able to take your image by default and use it in these models. Your location cannot be revealed outside of your friends. Content that you create can't be forwarded to others. And notably, these are all things that users can change, right? These aren't permanent settings, but by default, you start out private and then you can become public later on if you want to be, right? So that's one solution that's in this bill. Another solution is responsible notification. And the problem we're trying to address is that many consumers report having experiences with unwanted, disturbing, graphic, and sexual content, often powered by these AI algorithms. In one study at Meta that I'm familiar with, 70+% of users reported recently experiencing something that they wanted to see less of. They often saw it within the first 5 minutes of their use of the platform. They often would see it multiple times in their session. Now, oftentimes this kind of content is not particularly, it's not always super impactful on users. It could be disturbing content. It could be a fight video. It could be like sexual content that makes you a little bit more disturbed than you want to be. But it can have grave consequences, right? Especially with regards to our youth, right? And so one study that was convincing to me was a study by Common Sense Media put out a couple of years ago. That the average age of pornography exposure was age 12. And 58% of these kids who are seeing pornography were not looking for it. They were encountering it accidentally, right? These are algorithms pushing them content that they say they're not ready for. So our solution to this is simple. Instead of having algorithms that optimize for what you spend time on, we instead optimize for things that users explicitly say they want to see more of, right? Because we all know we're all guilty of spending more time on content that we know is not good for us, right? We've all, lingered on some overly violent, or overly graphic, or overly disturbing content, or overly sexual content. But that doesn't mean we want more of that. That just means we paid attention to it, right? And so if we actually anchor on what users explicitly want to see, or what they perceive to be high quality, we'll get better outcomes. And a lot of these users who are encountering content by accident that they don't want won't get that kind of content. Another thing that the bill talks about is sensible rate limits. So a lot of the problems that you see online are perpetrated by a small group of people who send out misinformation, who try to contact strangers with nefarious purposes. Most people are good people, just like most people in offline life are good people. But when you allow a small group of people to dominate a conversation, invariably that small group of people ends up being the problematic group. And just like in offline life, where we don't let a small group of people dominate our conversations, sensible rate limits can stop a small group of people in online life from dominating these spaces and making it unsafe and uncomfortable for others to participate. So our solution here are just sensible rate limits, right? If you're a new user, we don't let you exceed median user activity not for all activity. You can still read public content, but for the things that affect other users, things like inviting people to groups, commenting on people's threads, messaging others, making friend requests, right? These are things that you have to earn some amount of ability to earn some amount of trust to be able to do to a great extent. And then even for established users, we want to have some reduction on excessive usage impacting other users. And we're not saying you can't read other content or consume content, but we're saying the impact that you have on other users, just like in offline life, is subject to some limit so that you're not dominating conversations and impacting others in negative ways. Finally, the last design feature of this bill is not encouraging greater usage for kids. And so one stat that's convincing to me is 70% plus of kids in one common sense media study say that they feel manipulated by these platforms to spend more time on them, right? This is not us telling them that they are spending too much time on these platforms. This is them telling us that they feel manipulated. There's a stat on the screen, 55% of Minnesota college students say that they have an issue with excessive computer and internet use. Again, they're telling us they have a problem. 47% are saying that this is affecting their academics, right? So teens want solutions to help them use these products less, just like we all want solutions to use these products less, right? And so the bill mandates that these products just work differently for anyone who has a device that is under parental control. And you don't get things like optimizing feeds for time spent, right? Showing people that one last video that just will get you to use it just a little bit longer. Content feeds without infinite ending, or without finite endings, right? Otherwise known as infinite scroll, or auto-playing videos. Just giving people a chance to actually say that they want to use these products more, rather than just assuming that I'm just going to keep showing you content and showing you content, and you'll end up using them somewhat mindlessly. Providing notifications that are not time sensitive. So this is another thing that we don't want platforms to do. We've all gotten notifications from these apps that are just really not time sensitive, but are designed to increase our usage of them. Visible counts of engagement, ways that people gamify using these platforms so that some people feel some pressure to use them to keep up with others. These are all things that we want to ban, and the projected impact of this, we don't have any illusion that this is going to solve all the bad things that happen online. Just like bad things happen offline, sometimes bad things happen online too. But it will outlaw design choices that platforms know lead to the encouragement of these negative outcomes. And it will allow all platforms that are responsible to compete on a level playing field. So you won't have some platforms that engage in some of these design patterns out-competing platforms that actually do want to be responsible. And finally, I'll just end by just addressing, I did read some of the letters in opposition to this bill, and I just want to just assure you, as someone who's worked at a platform for a long time, it's not too vague to comply with. I can point to very specific work streams, app platforms that would comply with this bill. There are some terms that are, yes, subjective in the bill, but they are intentionally left subjective for users to define and for platforms to elicit that response, right? So we don't define what's quality. Users are defining what's quality, and platforms optimize for it. It does not ban algorithms. It actually just mandates that algorithms optimize for users' express preferences as opposed to what they spend time on. And yes, it does have privacy by default, which will restrict network effects. But users actually don't. I don't think that's a user concern. That's more of a business concern. In one common sense media study, more teenage girls really think that having public accounts has a negative effect than a positive effect. And we're just saying start with a private default, and then you can become public as you want. So that's my testimony. I really appreciate your time and attention, and I look forward to answering any questions you have. Thanks.
Next, we have Representative Bennett, House File 4335.
Could approach the bench, introduce yourself for the record, and begin your testimony. Thank you.
Can you hear me okay? Great. Thank you for being here, Chair, members of the committee. Thank you for the opportunity to provide testimony regarding HF 4400 on behalf of Chamber of Progress, a tech industry coalition promoting technology's progressive future and ensuring that all Americans benefit from technological leaps. I urge you to oppose HF 4400, which would produce a worse online experience for residents in Minnesota and almost certainly fail in court. HF 4400 would make Minnesotans' online experience worse. As written, HF 4400 requires platforms to let a varied set of account holders rate content that they deem as low or high quality, and mandates algorithms prioritize content accordingly for all adult users, severely limiting access to content based upon new interests. HF 4400 directs platforms to serve content based on popularity and in accordance with user preference, with no guidance on how to resolve situations where user preference does not align with or has not indicated a preference for a particular piece of content. The lack of clear, specific definitions could prompt social media platforms to broadly interpret the law so as to avoid litigation and fees, resulting in overmoderation, removing or restricting a wide variety of content, and leaving users with a bland or unvaried online experience. Worse still, the opposite threat is just as problematic. Bigoted users could coordinate it to rate racist, sexist, or homophobic content as high quality, gaming the system and algorithms, potentially forcing social media platforms to show deeply unsettling content to the public. Think about the consequences if radical groups were to brigade these platforms, as they commonly do, downvoting information on body autonomy or gender-affirming care. If companies may only rank content based on its popularity with other users, then the public may lose access to critical health information, as is already happening in red states across the country. HF 4400 infringes on these fundamental liberties under the First Amendment and would impose account holder daily limits regulating all adult users' social media usage in the initial 30 days of opening account. This requirement blatantly restricts access to constitutionally protected speech. An open internet, free from government surveillance and censorship, is critical to modern freedom of expression. We want to create safe online spaces, above all for the most vulnerable members of our society, but the legislature may not so broadly infringe on the First Amendment. So for these reasons, HF 4400 is destined to lose in court on First Amendment grounds, and for these reasons, we urge you to oppose the bill. Thank you.
Right. That is all the testifiers that we have signed up to share their thoughts on the bill today. Do any members of the public wish to testify on this bill? Seeing none, we can move to member discussion and questions. First on the list, Representative O'Driscoll.
Madam Chair, I just wanted to get on those. I'll speak last if there's others on my side that would like to speak.
Certainly. Representative Niska.
Thank you, Madam Chair. Thank you, Chair Stephenson, for engaging in this conversation. I think in a constructive way. I think every parent, certainly, probably every smartphone user, including myself, understands that this is a real issue that we have to grapple with. It's a difficult issue to grapple with for a lot of reasons, including really kind of an unsettled legal landscape as it relates to how we regulate the experience consumers have and the way that content is delivered to them and what their choices are in what content does get delivered to them without stepping over the line into regulating the content itself that people might choose to say and speak. I think that like I said, every parent, I certainly understand the concerns about social media and frankly smartphones themselves. So we all hopefully have come to understand in the last couple of years that real human face-to-face interaction is fundamentally different than interacting through a screen. That real accomplishment and achievement is different than a gamified accomplishment or achievement or cheap dopamine hits that we might get from a game or from a social media platform. And so this is an important issue that we should take on. I do have, I think, three main areas of concern about this bill, and I appreciate, Representative Stephenson, the fact that you have reached out and talked to people I know, including myself, but others as well, about these. And I hope that you'll that we can continue to talk about these issues. The first one is obviously the constitutional thicket that we're stepping into. As a state, we can and should regulate conduct that is harmful, but we cannot and should not regulate speech, regardless of whether we as a state government think it's helpful or it's harmful or wrong. This legal landscape is a little bit up in the air. There are two cases, obviously, in the U.S. Supreme Court, the net choice cases, that we don't know how those will come out, and frankly, we probably shouldn't wait for them to come out to try to find solutions to this. There's litigation around the age-appropriate design code legislation from California as well that we've discussed in this committee. But we need to figure out how to stay on the right side of that line, and hopefully we can have further discussions about that and make sure that this bill is doing that. The second one is obviously the workability issues. We need to do something that is workable, that's not eliminating the benefits of social media for people. And the third concern that I have is, in this context, I don't think a private right of action is an appropriate way to deal with this situation, where we're talking about the big social media platforms and the way that they present their platform or their product to the entire state of Minnesota. I think that that's something where that's best enforced by a statewide actor like the Attorney General, who would have the ability and well-established mechanism for reimbursing or providing restitution for individuals who are actually harmed. I certainly know that this Attorney General, the current Attorney General, is not. This is not going to be a low enforcement priority if this is passed, and I'm pretty confident that future attorneys general in the state of Minnesota are not going to consider this to be too low of a priority. So I do think that that's the right way to deal with this situation, through a statewide, politically accountable enforcement mechanism instead of a private right of action. But again, I'm tentatively voting to advance this at this point in time to the next committee, and I know we'll have further discussions along the line. So thank you. But thank you for your work on this.
Chair Stephenson, any thoughts at this point?
Well, first of all, thank you. I appreciate your willingness to continue in the conversation and work cooperatively on this. And I think that the issues that you identified are ones that are important to discuss. And I agree with much of what you said. Clearly, we have to be careful on constitutional grounds in this area. This area is inextricably intertwined with that issue. I think that the bill as currently written is pretty careful to stay away from regulating content, and in that way is pretty distinguishable as from the cases that were before the Supreme Court, which pretty directly and explicitly deal with content. But there might be more work that needs to be done there, and I'm happy to have the conversation. Workability, there's certainly more conversation there. And actually, I will say, we did put in the private right of action, in order to ensure that there is good enforcement of this. But I will admit to having mixed feelings about it myself. In addition to what you mentioned, I would note that bad cases make bad law. And this is an area where I think having the Attorney General decide what cases are being brought forward could result in a better definition of the legal landscape than if anyone can bring whatever lawsuit they want under this. So I'm open to that concept. There's definitely a trade-off there if you don't have the private right of action, but I'm open to the conversation about it.
Any follow-up, Representative Niska?
Thank you, Representative Kotyza-Witthuhn and Chair Stephenson. One last thing, I did want to give you an opportunity to address the idea that the testifier gave about that some group could kind of like hack the preferences for another person. The way I read the way that you're trying to draft Section 4, it sounds like it's more of you have to have both users' own preferences and a high quality in order for that kind of content to be something that's force-fed to users. But I just wanted to give you an opportunity to kind of talk about your intent on that provision.
Chair Stephenson.
Thank you, Madam Chair. Representative Niska, thank you for raising that, because I'm glad to correct the misunderstanding of the bill that the testifier clearly had, because the bill does the exact opposite of what he was saying. Under the bill, content has to be prioritized based on the user's preference. So you have to say, I want to see more of this or less of this, and they can't prioritize engagement over your own preferences. So if a platform knows that some other content is very engaging because a whole bunch of other people are asking to see it, but you say, I don't want to see it, what the bill says is they have to prioritize your view. So it's entirely the opposite of what he was saying. If there's a small group of people that are making content seem way more engaging than it otherwise is, you shouldn't have to see it just because these other people are engaging with it a lot and upvoting it and making it sound very, very good. And that's what the bill says. It says they can't prioritize engagement over your preferences. Puts the user in control. And so it's exactly the opposite of what the testifier was saying. I'm sure it's just a misunderstanding that can be corrected by looking at the bill more carefully.
Representative New Brinley.
Thank you, Madam Chair, and thank you, Representative Stephenson. I think we're heading in the right direction. I appreciate that. On this same point, I'm wondering, obviously, they can make this interface accessible to users to indicate if something is of high or low quality. It seems to be silent. It seems to be silent, and maybe that's the intention on, what happens if a user is not giving the thumbs up or the thumbs down, and then presumably it would just resort to a general algorithm where the generalized content is either considered high priority or low priority.
Chair Stephenson.
Madam Chair, Representative New Brindley, I think that that's correct. I think that what this bill really does is addressing is places where there's a conflict between what the user has indicated they would like to see and what the algorithm otherwise would show them. And so it's kind of regulating what happens when there's a conflict.
Representative New Brindley.
Thank you, Madam Chair, and thank you, Chair Stephenson. And clearly, there's a language about privacy. Would there be a place for, more generalized? When you're not, is this exclusive to an individual social media platform? Or would there still be, listen, I'm not a techie, cookies used or whatever, however this works, that would sort of indicate generally, what somebody is searching in their browser? Or would that play into this at all under this language?
Chair Stephenson.
Madam Chair, Representative New Brindley, I think this language is specific to social media platforms and the privacy in play there. So, cookies related to search history, my understanding of the language is it wouldn't really address that. It's worth noting, though, that the Elkins data privacy bill that we moved out of this committee has a lot to do with that. And I think that these bills kind of work together in that respect in terms of protecting privacy. I did ask Representative Elkins to kind of look over this language before introduction, and he thought that there was a natural connection between them, and they didn't contradict one another.
Thank you.
Representative New Brindley.
Thank you, Madam Chair.
Representative O'Driscoll.
Thank you, Madam Chair. More just some comments to the bill author. I concur with the testimony shared by, or feedback shared by my two counterparts here. The other thing I'm going to ask is, I think there is a possibility we get some bipartisan support on this, and I'm just wondering if you have engaged Representative Robinson, who has been a partner in this, and she could probably help you bring some insight into this and help you get that bipartisan support that I know you'd like on here. She's probably had 2 or 3 years where she's been working on the very same and similar. So just some advice to you about engaging her in this process may be helpful.
Chair Stephenson.
Thank you, Madam Chair. Thank you, Representative Driscoll. Very happy to work with Representative Robbins on this bill. I've worked with her, as you know, on her bill and heard it at least twice in this committee because I know that she and I have the same view about the need to do something about the impact social media is having on kids. And so, yeah, very happy to work with Representative Robbins.
Representative O'Driscoll.
And as luck would have it, her office is right next to mine, so either when you're stopping over to see me, stop over and see her, or if you're stopping over to see her, stop on and see me.
Chair Stephenson, final thoughts.
Thank you, members, for the good discussion today. We're going to keep working on this, and I'm hopeful that we'll get a result this year. It's a very important problem.
Chair Stephenson renews his motion that House File 4400 be re-referred to the Judiciary, Finance, and Civil Law Committee. All those in favor, please say aye. Aye. Those opposed say nay. The motion prevails. House File 4400 is re-referred to the Judiciary, Finance, and Civil Law Committee. I will give the chair back the gavel, and the next bill on the agenda is House File 4100. Representative Reyer, you can come forward.
Okay, before we pick up the bill, just kind of a reminder of the roadmap of where we're going today. We're going to take up House File 4100. We're going to have a bill presentation. We're going to go through testimony. We are going to do discussion to the extent that we can, and then no later than 2:10, we are going to lay the bill over. It will come back to this committee. When we come back, members will have the opportunity to offer amendments and discuss the bill further. We will probably not take additional testimony unless the testimony is specific to whatever amendment is authored, assuming we get through the testimony that's on the books today. So that's my plan for this bill. And with that, Representative Reyer, I will move House File 4100 be laid over for further consideration. I will also move your A1 amendment, which I assume gets this bill in the shape you'd like the committee to consider it today. Any discussion to the A1? Seeing none, all in favor say aye. Aye. Opposed? Motion prevails. A1 is adopted. Representative Reyer, to your bill is amended.
Thank you, Chair Stephenson and members. People need to be able to afford their lives. At the same time, businesses need to depend on people paying their bills. These two goals do not have to be in conflict. However, too many people are saddled with unmanageable debt, and our current laws do not support a successful resolution of this dilemma. That's why I'm pleased to introduce House File 4100, the Debt Fairness Act as amended. Minnesotans are under a great deal of financial pressure from consumer and medical debt, as you can see from the letters in your packets and online. We also know that medical debt, consumer debt, and financial distress are strongly intertwined. A new study by the Peterson Center on Healthcare and KFF found that people with medical debt are more apt to have no rainy day fund, be overdrawn, have credit card debt, use payday loans, or be contacted by debt collection. Plus, there are direct health implications. Again, from Peterson KFF, 59% of people with medical debt have chosen not to get care due to cost. It's just 17% of people with no medical debt. And generally, these impacts fall more heavily on communities of color. We need to address these problems, and because of the combination of consumer debt, garnishment, and medical debt provisions, this bill will help all Minnesotans who are struggling to make ends meet. I appreciate the conversations we've been having, many stakeholders and me, about this bill, and have noticed some common questions that I'd like to clear up. First, medical debt that is included in this legislation is only for medically necessary services. It does not include, for example, cosmetic surgeries or procedures performed in a clinic or by a doctor. Second, if a consumer pays their medical debt, their medical bill with a credit card, it will be treated as credit card debt, not medical debt for the purposes of, say, credit reporting. Third, long-term care is not included in the bill. Healthcare provider means health professionals, clinics, and hospitals as defined in the author's amendment. We're making good progress on the bill, working through concerns while maintaining a focus on the well-being of the people of Minnesota. My commitment is to continue working with all stakeholders and colleagues to deliver the best possible bill. With that, I'd like to turn it over to Assistant Attorney General Bennett Hartz to walk through the bill, and then welcome Attorney General Keith Ellison and our community testifiers Ann St. Martin and Nancy Lemmer. Thank you, Mr. Chair.
Thank you, Representative Reyer. So we will turn now to Mr. Hartz. If you just come forward, state your name for the record, proceed to your testimony. Welcome to the committee.
Well, good afternoon, Chair Stephenson, and good afternoon to this committee. My name is Bennett Hartz. I am an Assistant Attorney General in our office's Consumer Protection Division. The Attorney General is here today to support House File 4100, the Minnesota Debt Fairness Act. This act seeks to make Minnesota's debt collection system function the way that it should, allowing Minnesotans to pay back their debts fairly and affordably without being pushed by our laws into poverty, homelessness, and bankruptcy. Now, as an initial matter, the authors of this bill have just filed an A1 amendment. The amendment incorporates some language that was still being worked on by the House Reviser when the bill was first submitted. These are provisions regarding the denial of medical care, necessary medical care due to a patient's debt. It prevents patients from being unfairly charged for medical coding errors and incorporates requests for feedback from, among other stakeholders, the Department of Commerce. So the reason that the Debt Fairness Act is necessary is because the debt collection system that we have today in Minnesota is deeply and systematically unfair at essentially every point of contact with a person's life. Last year, the Minnesota State Bar Association published a report that analyzed 10 years of public consumer debt lawsuits in Minnesota. This is about 700,000 lawsuits, and found that consumer debt collection cases, these are lawsuits for medical debt, for credit cards, for payday loans. These make up more than 50% of all cases in our judicial system. And in the overwhelming majority of these cases, this is 82% of consumer credit cases, the consumer who is sued couldn't even afford to respond. And so the creditor got a judgment by default, typically in almost every case, also getting their attorney's fees and court costs pushed onto the consumer as well. Now, once a creditor obtains a judgment like this, they can basically renew it forever. There is effectively no statute of limitations on consumer judgments in Minnesota. The law lets creditors levy people's bank accounts to zero, suddenly leaving them no money left over to pay their rent, to pay for their mortgage, for their car, utility bills, daycare. This is something that people often discover when they're in line at the grocery store trying to pay for groceries, or they're at the gas pump trying to put gas in their car and their payment gets denied. Now, on top of this, Minnesota law also lets creditors take up to 25% of people's paycheck, an amount which for the vast majority of people on the receiving end is totally unsustainable. If they have a rainy day fund, which a lot of people who are the target of garnishment do not, it eats that up, and then people end up taking on more debt to try to plug the hole being caused by the garnishment, robbing Peter to pay Paul, as we say. Now, for medical debt, it's even worse because recent reporting has found that some Minnesota healthcare providers are denying medically necessary care to patients to try to get them to pay a previous bill. Another example is that medical debts, some of them can be automatically intercepted from people's tax refunds without the due process of a court case. Just the fact that they owe it is enough for them to lose their refund. And I personally think, worst of all, under Minnesota law, you are automatically liable for your spouse's medical debts. So this has led, in some cases, after a person's death, to their widow or their widower having to file bankruptcy for their deceased spouse's medical bills. But even in the bankruptcy process, Minnesota's laws are out of date and inadequate for debtors going through it. Minnesota law lets you keep, for example, your phonograph or your TV receiver box through bankruptcy, but it doesn't let you keep your cell phone. Creditors in bankruptcy can take engagement rings, work trucks, the money in your bank account for rent, even the primary vehicle of a lot of people. And Minnesota law protects the family Bible, but it doesn't protect the sacred possessions of people belonging to Judaism, Islam, or any other religion. Now, across the whole collection process, consumers have some limited rights against the worst abuses, like illegal threats or getting spammed with robocalls. But these rights only apply to some collection and not to others. And consumers are essentially powerless to stand up for their rights. The law gives them very limited ability to actually defend their rights here. And these enforcement capacities are relegated to a few attorneys at a few state agencies. Now, the outcomes here are all decisions made by Minnesota law, and they can be changed with this bill. Now, the Debt Fairness Act seeks to make the debt collection process fair for everyone so that the precarious but necessary function of debt collection in the financial system doesn't push working families into poverty and instead allows them to pay back their debts fairly and with dignity. So to that end, the Attorney General's Office supports passage of HF 4100. Thank you all for your attention and time to this critical issue.
Thank you, Mr. Hartz. I did want to just, on a totally unrelated note, there was some noise earlier that I'm sure everyone was wondering where it came from, and we did get an update. It was they were using the loading dock next door, and that's what the noise came from the equipment they were using over there. They're not going to come back. And maybe along with the Wi-Fi issue where we had to ask you to not use Wi-Fi when we were using the Zoom here, maybe is a good illustration of why there's a need to do work in this particular building going forward. The next testifier is the Attorney General. Attorney General Ellison, welcome back to the committee. Always a pleasure to have you here.
Mr. Chairman, members, thank you all for having me here today. Minnesotans work hard to provide for themselves and their families, as we all know. We're a state where most folks play by the rules and meet their responsibilities. But when life throws up roadblocks, we can all stumble. Sometimes we fall behind on our debt because of severe illness, because of injury, because of unexpected repair bills, divorce. It's all human. Now, don't get me wrong. I believe, and this bill stands for the idea, that if you owe money, you borrow money, then you should pay it back. We all can agree on that. But you know, the terms, the rate, the amount, and all these things are things that we should discuss to make sure that the repayment of this debt is fair to all concerned. We should also all agree that you shouldn't be punished because you got sick. We should all agree that a debt collection system that makes it harder for people to pay back what they owe doesn't do anyone any good. And we should agree that debt collection shouldn't create more debt. The debt collection process should be fair and dignified. People trying to catch up and pay off their debt should be able to do so without being exploited or pulled into poverty. Instead, our debt system is full of unfair loopholes and policies that make it harder for people to repay their debts, even when they're really trying hard to do so. We've received, at the AG's office, reports from expectant mothers who were told that they could deliver at the hospital, but due to outstanding bills, they would be on their own after delivery. We have heard from a single mother of 2 from Cloquet in the process of being evicted when she was hit with a garnishment. She was trying to find a new apartment or family, but losing 25% of her wages made paying security deposit impossible. A woman in Cambridge who earns $400 a week had her bank account levied by a collector and totally cleaned out. This put her on the brink of homelessness. Our office has heard from hundreds of people in stories like this. Last fall, the Access to Justice Committee of the Minnesota State Bar Association produced a report on consumer debt litigation last year that painted a stark picture of how our broken debt collection picture is in Minnesota. People are getting dragged into court over debt at an alarming rate. More than half of the civil cases in Minnesota courts are debt collection lawsuits, even though Minnesota has fewer debt filings than most other states. And Minnesotans of color are disproportionately impacted by this. Overall, the rate of debt claims filed against Black and Latino Minnesotans is more than twice that of non-Hispanic white Minnesotans. And these racial gaps hold true for all income levels. Now, it doesn't have to be this way. The Minnesota Debt Fairness Act is one path to fixing our broken debt collection system, making it fairer and easier for Minnesotans to work their way out of debt. It strengthens the guardrails in 3 areas: medical debt, wage garnishments, and collections. Medical debt is unique. You don't apply for it like a mortgage or a car loan. You don't have the luxury of planning how much you want to borrow, or when you want to borrow it, or how you're going to pay it back. It is very much unlike going into an electronics store and buying the biggest television you see on credit. It's actually quite the opposite of that. And because it is unique, because we don't plan for it, we don't plan how much we borrow, because we don't even have the right to shop for the best product and the best price, we should treat it unique as it is. When it comes to garnishments, Minnesota law currently allows creditors to drain every cent of our consumers' bank accounts, which can force people further into debt just so they can pay for the essentials like food, housing, or transportation. Minnesota does have some common sense rules to prevent threats or harassment from debt collection agencies, but right now they don't apply to banks, credit card companies, or medical systems. The Debt Fairness Act would address these issues and more. The bottom line is that right now, our debt collection system can be both unfair and undignified. So last fall, my office pulled together a collaborative effort to fix it. We heard from lenders, researchers, experts, and heard from communities in the urban areas, rural areas, suburban areas, people, Minnesotans of all walks of life. The Minnesota Debt Fairness Act is a better way forward, and I'm proud that my office has worked with advocates, stakeholders, and authors, Senator Bolden, Representative Reyer, to move it forward. I'd like you to know as I wrap up that I have heard from really more people than I can count. I have letters here from Minnesotans from all over our great state, from various organizations, and you may hear from people on all sides of this, but I assure you the problem that we are trying to address is real and it's serious and it affects Minnesotans from all walks of life. In particular, I've been hit by letters from the ALS Association and from the Multiple Sclerosis Society, people who really need help when the medical debt issue begins to be prominent in their lives. So thank you for listening, Mr. Chair, Ranking Member, and all members, and I look forward to a robust dialogue. I understand that you're just taking testimony today, so I'll come back when it's time for questions.
All right. Well, thank you, Mr. Attorney General, and thank you for your office's great work on not just this bill, but the one we heard right before it. Really, really appreciate your leadership on both of these issues.
Thank you, Mr. Chair.
So we have two more testifiers before we get to the public testimony. I'm going to ask each of those testifiers to limit their remarks to about 2 minutes. First is Ann St. Martin, will be followed by Amy Lemmer. Please state your name for the record. Proceed your testimony.
Excuse me. Thank you, Chairman Stephenson. My name is Ann St. Martin. I am from Inver Grove Heights, Minnesota. I live there with my husband, Dennis, and my two sons, Joe, who is 9, and Leo, who is 7. I'm here today as a mother, a rare disease mom, but also as an advocate for the Minnesota Debt Fairness Act, HF 4100. This act would provide much-needed reform to Minnesota's medical debt system and a change that is crucial for families like mine who are navigating the challenges of rare disease. So my journey with medical debt began when my son Leo was diagnosed with Pompe disease at 4 months old. His rare disease requires an expensive treatment. Enzyme replacement therapy costs up to $500,000 a year. Despite having very good insurance with my husband's union, we face exorbitant costs. So we are also enrolled in the MA TEFRA program. We understood Leo's disease would be costly, and we did what we needed to do to get the best coverage. We pay $1,800 a month, and we expect the insurance and the coverage to be there when we needed it. In 2022, we were approved for a new drug, which was a more efficient medication for Leo. Our team of doctors from a reputable institution were tasked with filling out the prior authorization forms to get this more efficient medication. The same institution then told us we were approved and helped us get scheduled for our new treatment. However, due to a billing code error in the paperwork that they submitted, caught after our 4th dose, insurance denied coverage for the drug. They then retroactively denied payments for the previous doses and the hospital stays. This left us with a $250,000 medical debt bill for the drug and miscellaneous hospital charges. We were also then left with no treatment for 3 months for Leo, who has an incurable and progressive disease. As of today, the hospital has advised us that they are trying to get the bill paid in other ways, but at the end of the day, they may send us a statement. Once we get that, we have 18 months to pay the bill. If we fail to do that, the hospital will then proceed with legal garnishment of my husband's wages. The burden of medical debt is not just financial, it's emotional, and it's a mental one as well. It affects our well-being and our ability to provide for our families and care for our loved ones. For families like mine, the burden's not just managing rare disease, but also navigating insurance, doctors, hospital systems. We trust our doctors and insurance companies to work together and to not charge us when they make a mistake. It is also not lost on me that I'm a white, college-educated, middle-class woman. I have the resources to advocate for myself and for my son. I'm fully aware of the privilege that my standing in society gives me. And it really does break my heart for the other rare disease families out there that don't have access to the things that I have access to. I can't imagine how hopeless and scared they must feel if they get a $250,000 bill. Will they choose between putting food on the table or paying a medical debt bill caused by a clerical error? The Minnesota Debt Fairness Act, HF 4100, would provide much-needed relief to families like mine. It would ensure that billing errors do not result in crippling debt, and it would give us the support to focus on our loved ones. It would put more responsibility on the medical institutions that you entrust to do their job correctly. We should not be expected to be medical or insurance billing code experts on top of the other things we do in the rare disease world.
And if you could just conclude your testimony.
Yes, sorry. I urge you in supporting the Act, HF 4100. Thank you for your time today.
Thank you. Next, we have Amy Lemmer, who will be followed by Ronald Lundquist. And maybe Representative Reyer, if you want to sit at the committee table, and then Mr. Lundquist can come down, he can start right after Ms. Lemmer. So welcome to the committee. State your name for the record. Proceed to your testimony.
Amy Lemmer. Mr. Chair and members of the committee, thank you for allowing me to share my story today. Sorry, it's a little bit tough.
Take your time.
In September of 2021, I filed for divorce. In trying to navigate this, I was living in a very volatile environment. Things continually got worse, and on December 31st, he told me that he was going to buy a gun, and I better not be here when he got back. My sons and I moved the next day. He threatened me daily. His exact words were, "I'm going to make you homeless, bankrupt, a convicted felon, and lose your children." I was able to achieve full-time status. Sorry.
It's okay. Take your
But
time.
having to start over, the financial strain was severe. About a month later, our HR representative advised me that my paycheck was going to be garnished by a law firm for a total of $600 a month. I was shell-shocked and panicked. I would never want anyone else to feel this. I was barely making ends meet. The sleepless nights and anxiety became worse and worse. I called the law firm and let them know about the domestic, financial, and emotional terror that I was going through. If the garnishment continued, I would not be able to provide for my sons. I never got any notice that my funds could be protected or that an exemption, nothing. As the garnishment continued, I fell behind on bills. My gas was shut off, and another law firm, not being able to garnish my wages, froze my bank account and withdrew over $750 of my child support. This was financially debilitating. If this bill would have been in effect during my crisis, it would have helped me immensely. This debt was from 2007 and was renewed not once, but twice. The part of the bill that would prevent that would have helped me tremendously. As I was fleeing my abuser, my family members were trying to help me with loans to pay my bills. If this bill were in effect back then, the money in my account would have been protected so I could just cover my basic needs. I would not have gone through so much financial and emotional suffering. I would never want another person to go through the hopelessness, anxiety, and the fear of not being able to provide for their family. This is why I hope you support this bill moving forward.
Thank you. Thank you for sharing your story with the committee. I know it was difficult, and I appreciate it very much. So we'll now move on to public testimony. We're going to start with Mr. Lundquist. Next will be Tess Rice. So when your name is called, come on up and sit in the other seats so that we can just keep going back and forth. Mr. Lundquist, state your name for the record. Proceed to your testimony.
Mr. Chair and members of the committee, my name is Ron Lundquist. I'm an attorney in Eagan. I'm a former member of the Rules Committee as well as the Practice Committee for the Bankruptcy Court here in the state of Minnesota, as well as a former chair of various committees for the Minnesota State Bar Association Bankruptcy Section. Currently, I'm on the board of the Minnesota CLE Bankruptcy Institute, as well as a member of the board of directors for the Volunteer Lawyer Network. My practice is focused on helping clients who, because of illness or disability or unemployment or underemployment or some other personal calamity, are forced to consider often tearfully bankruptcy relief against aggressive creditors. Now, I want the committee to know that people don't file bankruptcy to evade responsibility. They file because their backs are up against the wall, threatened and intimidated by creditors, often medical creditors. Bankruptcy is truly a last resort for Minnesotans at their wits' end. In this regard, it's critical to modernize Minnesota's debtor-creditor law, including our exemption laws. Now, exemptions are categories of property that protect basic property from creditor seizure. But our current exemption laws are woefully, embarrassingly, and terribly outdated. Just to reiterate what Bennett Hartz had mentioned, our current Minnesota law protects the phonograph, but it doesn't protect a computer, which maybe makes Thomas Edison happy, but not the Minnesotans who are directly affected by this. Current Minnesota law protects a Bible or a church pew from creditors, but not a Koran or a prayer rug. Current Minnesota law protects a claim for personal injury, but it doesn't protect the settlements from such a claim. Current Minnesota law will not protect a claim for harms that we now realize are serious and valid, such as harms caused by sexual or emotional abuse. Please pass this legislation. Give life to the spirit of the Minnesota State Constitution, which states at Article 1, Section 12, that, quote, a reasonable amount of property shall be exempt from seizure or sale.
If you could conclude your testimony, please.
For the payment of any debt or liability. Thank you very much.
Thank you. Next, we'll have Tess Rice, who will be followed by Dan Lee. Ms. Rice, welcome to the committee.
I am Tess Rice. I am General Counsel for the Minnesota Bankers Association. The MBA is a trade association. We represent 280 banks in Minnesota, about 95%. Our median bank size is a small business with 15 to 20 employees. We have more than 200 community banks that are small and medium-sized businesses. We have concerns with about 20 provisions in this bill, but for time's sake, I just want to focus on a couple, and we are happy to provide all of our concerns in writing. First, we're concerned about being looped into the collection agencies chapter. Banks have never been part of that. We do not collect third-party debt. We collect only our own debt. We are also highly regulated in this area. Every bank is regulated by a federal banking agency, and they have their own rules for this. They also expect banks to follow the Federal Debt Collection Practices Act. They are closely examined for their compliance and subject to severe civil penalties if they do not comply. So this would leave them trying to navigate both the federal laws and the state chapter and trying to figure out what to do if they don't mesh up. We haven't heard of any reason why banks are being included in this. I have checked with the Department of Commerce. They are not aware of any complaints against any banks in regards to debt collection. The second thing I wanted to mention was the bill makes significant changes to the garnishment and levy statutes. One of the things that it does is the state statute requires banks to hold funds for creditors and then pay out those funds. So we're doing this because we're required to do it by statute. It takes away our right to charge for this service. So creditors currently pay us $15 to do this work, and we are also allowed to charge our customers a garnishment fee. But there's some misconception with the proponents that this does not take a lot of work. Garnishments are actually very difficult and full of judgments that must be made. Our attorneys at the MBA answer hundreds of questions a year on garnishments. We have classes and webinars. We have 30 pages in a manual dedicated to it, including flow charts to help them navigate it. It's difficult. And there are at least 10 steps from making sure the service was proper to sending exemption forms to paying out the funds. And anytime we make a mistake, we could be sued for that. One tricky issue is joint accounts, and that's mentioned in this bill. This bill creates a new notice requirement where we will have to send a notice to a joint account owner, giving them the opportunity to say, hey, this is my money, not the other person's money. I'm not the debtor here. And that's
need
all.
you to conclude your testimony.
The issue with that is that they put the bank in the judgment seat to determine whether that proof is enough, what they should provide for proof, and whether that's enough. So we thank Representative Reyer for meeting with us this morning, and we look forward to working with the other stakeholders on this bill. Thank you.
Thank you. Next, we have Dan Lee, who will be followed by Buck McAlpin.
Chair Stephenson's members of the committee, thank you. I'm here to speak on behalf of the Minnesota Credit Union Network and our 86 member credit unions, 30% of those serving very small in asset size, serving underserved and underrepresented populations. I want to thank Representative Reyer for meeting with us earlier today to speak about our concerns. I would echo those same logistical concerns and ask the committee to consider the fact that members are the owners of credit unions. Credit unions are integral parts of their community, and we want to be a part of helping people who've suffered the crushing impact of medical debt and its involuntary nature to rebuild their lives. But we are also concerned with the challenges that this bill may increase with compliance costs and other related things such as traceable funds. I'll conclude my comments for now, make myself available for questions or further follow-up information after today. Thank you.
Thank you. Next is Buck McAlpin, who will be followed by Jessica Clander.
Mr. Chair and members, Buck McAlpin here on behalf of the Minnesota Ambulance Association. I'm here to talk about Section 3 under claimant agency, and we also had good conversations with Rep. Reyer in the past about just the funding piece. We just completed an EMS regulatory board audit. It's probably a bill you may have saw for about $120 million of funding. That's a gap that's being subsidized now by large healthcare systems across the state and local units of government. And we just want to be sure as the conversation continues that we look at how we fill that gap when we take away the tool for revenue recapture. This takes it away. Well, Minnesota allows all ambulances, regardless of your affiliation, to do that. And we've been talking to Representative Reyer about other opportunities to look at that funding bucket to be sure we replace that money.
Thank you. Next, we have Jessica Clander, who will be followed by Derek Weber. Welcome to the committee.
Thank you, Mr. Chair, members of the committee. My name is Jessica Clander. I'm an attorney at Bassford Remley, and I'm here on behalf of the Great Lakes Credit and Collections Association. Taken together, the provisions of this bill radically change the collection process and cause unintended consequences. The proposed legislation reduces the statute of limitations for obtaining a judgment on consumer debts from 6 to 3 years. It also eliminates any ability to renew a judgment. The impact of this significantly reduced timeframe would have negative impact on creditors and consumers. The current 6-year statute of limitations provides time for creditors and collectors to work with consumers to voluntarily resolve their debts. Typically, a debt is not even placed with a collection agency for 6 months to a year after the original creditor's attempts have failed. In the case of medical debt, the timeframe is longer, more than 18 months, to allow for the bills to be processed by insurance. After a debt is placed with a collection agency, the agency will try for another 1 to 2 years to reach a resolution. If that fails, it may get sent to another collection agency, and that process continues. This slow and methodical 3 to 5 year process provides the consumer with dozens of opportunities to voluntarily resolve their debt before being taken to court. The 3-year statute of limitations would compel creditors to fast-track their collections process and resort to legal action sooner. A shortened time frame does not help the consumer because it would reduce the time frame for voluntary resolution. Similarly, with shortening the statute of limitations on the judgment itself from 10 years to 5 years, it further shortens that period of time for voluntary collection processes. Creditors would be forced to initiate a garnishment action sooner in order to obtain recovery when that is going to expire and be extinguished in such a short period of time. This proposal would make Minnesota the only state with a 3-year statute of limitations coupled with a 5-year non-renewable judgment in the country. The impact would be the shortest time frame for collections in the country. That makes collections harder, making businesses more cautious to extend credit and further reducing access to affordable credit, particularly for those at the very bottom. GLCCA shares the desire to protect consumers from harmful practices, but we believe this proposed legislation goes too far and would result in negative unintended consequences. Thank you so much for your time. I appreciate it, Mr. Chair, members.
Thank you. Next is Derek Weber, who will be followed by Mary Krinke.
Thank you. I've been a practicing attorney for over 30 years, the last 22 years with the law firm of Mesterly and Kramer. Over that time frame, I've represented consumers and creditors. I'm here on behalf of the Minnesota Creditors' Rights Association, which is an organization that is over 20 law firms and their lawyers and paralegals and support staff who represent creditors. Initially, one of our concerns was the bill's proposal to have the Department of Commerce regulate the practice of law, and we are thankful that that's been amended and dropped in the proposed bill. But we've had a long history of working with the Attorney General and legal aid and the legislature to really improve our debt collection laws. And for example, we're the group behind the updating of the garnishment statutes and the forms. We helped create the assigned debt default bill. We worked with the SOL statute, statute of limitations statute, and we most recently worked on the coerced debt to help that get through. And so we're actively involved with you all to try to come up with laws that make sense. And so one consistent theme that we've all had, and you heard it again by the Attorney General this morning, is that people should be required to pay their voluntary debts. Someone goes into the store and buys the largest big screen TV and borrows money, they should be obligated to repay that. The problem is that this bill goes too far and seeks to eliminate judicial remedies that will, in effect, eliminate the obligation to pay the debt. In some ways, the bill contradicts itself. For example, it gives the consumer more time to pay, but reduces the amount of time collectors have to collect. And so we would like an opportunity to walk through some of that. The bill's proposal has, Minnesota has a very detailed and comprehensive exemption statute, and the bill's proposal to automatically exempt $5,000 in every single bank account that you can open up is too far.
I'll need you to conclude your testimony.
Thank you. There are many other objectionable provisions with the bill, but some are not, right? And so respectfully, on behalf of the Minnesota Creditors' Rights Association and a large group of attorneys and their law firms, we would like the opportunity to work with the bill's proponents, work with the Attorney General and legal aid, and come up with a solution that makes sense. So,
Great.
Thank you.
And the final testifier is Mary Krinke. If you just come forward, state your name for record, proceed to your testimony.
Mr. Chair and members of the committee, for the record, my name is Mary Krinke, and I'm with the Minnesota Hospital Association. We hope that legislators can find the right balance, and we did have an opportunity to talk with Representative Reyer this morning as well. We hope that legislators can find the right balance between how do we help low-income individuals better afford their health care services, while at the same time making sure that our nonprofit hospitals and health systems are being paid for services that have been delivered. Everyone knows this, but I think it's important to restate. Hospital emergency departments are always open to everyone, regardless of their ability to pay. This is not limited to a certain number of individuals, nor does an individual have to have a scheduled appointment. The mission is becoming more and more difficult, particularly as government payers right now, the Medicaid program is paying hospitals on average 70% of our 2019 base costs. Financial challenges would be created for hospitals and health systems because of the interactions of three key provisions of the bill. Doing one of these proposals would not be that bad, but taken together, the three collectively would mean that there would be very little incentive for anyone to pay their bills. These provisions are, number one, if medical debt cannot be reported to a credit bureau. Number two, combined with no interest charges on any medical debt, combined with a policy of no refusal for any clinical services. When these three are taken together as a whole, there's no harm in not paying your medical bill. MHA suggests that these three proposals be tied to some type of upper income level, and we've talked about maybe possibly using the threshold of 400% of the federal poverty limit, which seems reasonable given that that is the threshold that is currently available for getting a subsidy on MNsure to purchase insurance. Most hospitals and clinics do offer payment policies and work with our patients on a regular basis to help them pay their debt. I'm just throwing out today the possibility of maybe we could have a one-year period where there would be no imposition of debt, no imposition of interest, and no imposition of reporting this to a credit scoring. There'd be a one-year period. We would work with people to help them pay their debts.
And to conclude.
Thank you. Yeah. In closing, I just want to have thank Representative Bierman, who is the chief author of a bill, House File 3840, that shifts the responsibility of collection of debt from and partially from the hospitals to the health plans. This would be for emergency room services as well as ambulance services. We do not want to be in the debt collection process. We'd rather be care providers. Thank you, Mr. Chairman.
Thank you. We'll now move to a little bit of member discussion and questions. We have just a few minutes. We'll start with Representative Farr.
Thank you, Mr. Chair, and thank you, Rep. Reyer, for this bill. I'm hoping that we can work on this. Just a couple of questions and then thoughts. So on line 3.5, I don't think I've ever seen before in one of these allegedly obligated. I understand what obligated is, but what is allegedly obligated debt? Just seems interesting to me.
Representative Reyer.
Yeah, thank you. Thank you, Mr. Chair. Thank you, Representative. I would like to ask if Mr. Hartz could come down.
Mr. Hartz, if you could come down. Mr. Hartz.
Sure thing. I'm sorry, I could hear the question, but I'm not sure which member I'm directing my response.
Representative Farr.
Thank you, Chair Stephenson, and thank you, Representative Farr, for your question. An alleged obligation recognizes the fact that sometimes people are being asked to pay a debt that they don't actually owe, and we don't want a person in that situation not to have the same rights as a person who actually does owe the debt.
Follow up, Representative Farr?
Yeah, and so if there is a garnishment, levy, judgment, the courts would have decided that that is an obligated debt, correct?
Mr. Hartz.
Thank you, Chair Stephenson. Representative Farr, that's correct. If it's in a garnishment or levy context, then yes, it would not be an alleged debt anymore. It would be well, you have to remember the context in these cases. 80-some% of people are not even able to show up to defend the case. Sometimes these judgments can be vacated. They can be overturned when the person actually appears before the court and says, essentially, I didn't have notice, I didn't have counsel, I didn't know what to do with this case. Here you can see that I paid this to a previous collector. I paid this to somebody further downstream, and so this debt that's being alleged against me as a judgment is actually one that I don't really owe. But I appreciate the distinction, and think we'd be interested in hearing whether you would want that language changed in any way.
Representative Farr.
Define unable to attend, 80% unable to attend.
Mr. Hartz?
Does that choose not to attend, or?
Chair Stephenson, thank you, and Representative Farr. There's a huge variety of reasons people don't show up. I would say that for those of us sitting in a committee meeting who are attorneys who have experience with the legal system, responding to a lawsuit is, maybe not the most pleasant task, but certainly something we would know how to do. The vast majority of people don't have that experience, and when they get served with a summons and complaint that tells them, not to show up and defend themselves in court the way that you would in small claims court. In small claims court, for the record, appearance rates are higher. These are district court cases. It says, submit an answer in this manner. It has to respond to these points. The vast majority of people in this situation, are being selected for not having any money or disposable income at that point. So they can't get an attorney. They don't have the knowledge base required to understand, because our laws make it challenging for them to understand what that paperwork is. So when I say unable, I don't mean physically prevented, but I think the numbers bear out that the vast majority of regular people in those situations don't know how to respond to that lawsuit.
Okay, so it's 2:11 now. I said we were going to set this bill down at 2:10. I'm going to offer Representative O'Driscoll if you want to make brief comments before we lay the bill over today. Members, you will all have the opportunity to discuss the bill when we bring the bill back up again and ask questions. But Representative O'Driscoll.
Yeah, just procedurally, and I realize we want to get this done. Is there possibly any member that has questions that a testifier who may not come back at the future that we want to ask today? That's just throwing it out there for the process as well.
Is there anyone who's got a question for a testifier? It has to be a very discreet and quick question, but I'm not seeing hands going up. So we'll just, at this, Representative New Brindley.
Mr. Chair, I just have a question for you.
Yeah.
Just procedurally, is it possible to consider getting an unofficial engrossment of this before we bring it back up again? The amendment is really meaty, and it's tricky to navigate between the two documents.
I won't make a promise of that, but we'll look into how we can help you with that.
Thank you.
Yeah. All right, with that, we're going to give Representative Reyer, if you have 15 seconds closing before I lay the bill over today.
Mr. Chair, thank you all very much for your attention. Thanks to the testifiers. Look forward to the next steps.
And I will add, Representative Reyer will work with anyone I know from her reputation and working with her in the past. And she's already been working with a lot of people, and I'm sure anyone who wants to work with her, she would be glad to work with. And with that, the bill is laid over. The next item on our agenda is House File 4040 from Vice Chair Kotyza-Witthuhn. And as people are leaving the room, if you could please do your best to do so quietly so we can keep working, that would be great. We've got two more bills, Representative Kotyza-Witthuhn, but they're quick. They're quick. All right. Would you like to move your bill, Representative Kotyza-Witthuhn?
Thank you, Mr. Chair. I would move that House File 4040 be placed on the general register.
Representative Kotyza-Witthuhn moves House File 4040 be placed on the general register, and you have the A1 amendment. Would you like to move the A1?
Thank you, Mr. Chair. Yes, the A1 is a technical amendment, and if anyone has any specific questions.
Gets the bill in the shape that you'd like to consider it. Any discussion to the A1? Seeing none, all in favor say aye. Aye. Opposed? Motion prevails. A1's adopted. Representative Kotyza-Witthuhn, to your bill as amended. Mr. Kelly?
Mr. Chair, for the record, John Kelly, Director of Government Affairs for the Department of Commerce. The amendment is on 4041, not 4040. Oh, that's right. We did have an amendment. I forgot. I'm sorry.
It was a spelling mistake.
We'll stick
so
with the
very
adoption
technical.
of the amendment, and we'll Representative Kotyza-Witthuhn, to your bill as amended.
Thank you, Mr. Chair. So, members, House File 4040 is the Commerce Department Securities Policy Bill that makes important updates to statutes and direction to the department to do rulemaking that will allow the department to better serve Minnesota's investment advisor representatives, investors, consumers, and businesses. I'm going to let Mr. Kelly do a very brief walkthrough.
Mr. Kelly.
Thank you, Mr. Chair and members. House File 4040 is the Department's Securities Policy Bill. As Representative Kotyza-Witthuhn mentioned, it makes some updates to our securities and franchise laws and rules. The first, it includes a notice filing requirement for Regulation A Tier 2 securities offerings. It updates examination requirements for an investment advisor representative to include the General Securities Representative Examination 7. This was taken out of statute in a housekeeping bill a few sessions ago, and it's the Attorney General's office asked us if we could get that put back in, even though most folks have both. We want to make it explicit, so that's going. We're asking for that to be put in. We are asking for rulemaking authority to update the Department of Commerce's rules around continuing education requirements for investment advisor representatives to incorporate the North American Securities Administrator Association Model CE rules. And then lastly, we are adding, in addition to our franchise statutes currently, we are able to offer a deferral of the administrative fee for a franchisor until the business is up and running. We're doing that administratively. We want to put that in statute. So all of these updates are about protecting Minnesota consumers and investors and making it easier for the folks in the field that are doing this work and more consistent across state lines. North Dakota and Wisconsin have adopted the NASA Model CE requirement rules, and so we're just trying to get into alignment for our investment advisor representatives that are licensed in multiple states. And with that, I'll stand for questions.
Are there any members of the public wishing to testify to this bill? Seeing none, any member discussion to the bill? Representative O'Driscoll.
Thank you, Mr. Chair. Just one clarification for Mr. Kelly. When he and the commissioner in my office, I had asked the question about the additional continuing education or for clarification, and Mr. Kelly said that he thought he might have some information available for us at the committee meeting relative to that. And the question I had raised with you, Mr. Kelly, just to put it back in context, is the annual firm element continuing education requirement. Is this in addition to what you're proposing for IAs, investment advisors, or is it just looking for some clarification on are they going to have times two, or is it an expanded firm element? Where are we at?
Mr. Kelly.
Thank you, Mr. Chair and Representative O'Driscoll. So the reg in this is for is not for it's not for firm element, it's for regulatory element. So my understanding is that the regulatory is a FINRA and firm is for the broker dealer. So the firm element would be tailored to the specific to the broker dealer, but the regulatory is broadened from FINRA.
Representative O'Driscoll, any follow-up?
Just quickly, then, why have we not had that as a requirement in Minnesota if it's been a FINRA requirement in the past?
Mr. Kelly.
Mr. Chair and members, if it's all right, I have our Chief Securities Examiner here, or Director here. She might be able to quickly answer this rather than me muddling through it.
Absolutely. Just come forward, state your name for the record, and then you can answer Mr. Representative O'Driscoll's question if you can.
Hi, everyone. Amanda Kelty, the Chief Securities Director for the state of Minnesota, Chair Representative. It's a model rule that was passed a number of years ago, and we will be one of 18 states to hopefully adopt this moving forward. I'm not sure why it wasn't adopted historically, to be perfectly honest. I've been with the department about a year now. So the goal of doing this is to get at the individuals who are not otherwise receiving CE through other means. So there's individuals who may have a designation where some of the CE requirements will be met. They may be registered in another state. So if you're registered in Wisconsin and this already applies there, you don't have to redo it. It's not like a double down. And then for the additional CE, if you're registered with another broker dealer, it cuts out some of the credits as well there. So again, you don't have to do the extra work. We're really trying to get at people that are not otherwise covered for other means.
Representative Driscoll. Okay. Closing comments, Representative Kotyza-Witthuhn.
Thank you, Mr. Chair. And Representative Driscoll, that was actually a question I had in the process too. So thank you for that clarification. Mr. Chair, this bill enables the Department of Commerce to empower Minnesotan business owners to expand with confidence, and I would appreciate everyone's support.
Representative Kotyza-Witthuhn renews her motion that House File 4040 be placed on the general register. All those in favor say aye. Aye. Opposed? Motion prevails. House File 4040 is recommended to be placed on the general register. The next item on the agenda is House File 4041, also from Representative Kotyza-Witthuhn. Would you like to move your bill?
Thank you, Mr. Chair. I would move that House File 4041 be placed on the general register.
Representative Kotyza-Witthuhn moves House File 4041 placed on the General Register. You have the A1 amendment, which I assume gets this bill in the shape you'd like us to consider it.
Thank you, Mr. Chair. Yes, I would move the A1 amendment to get the bill in the shape I would like.
Representative Kotyza-Witthuhn moves the A1 amendment. Discussion to the amendment. Seeing none, all those in favor say aye.
Aye.
Opposed? Motion prevails and the A1 is adopted. Representative Kotyza-Witthuhn to your bill as amended.
Thank you, Mr. Chair. This bill, House File 4041, includes and addresses a few requested changes by the banking and mortgage industry here in Minnesota, and it modernizes key provisions to the statutes and rules that govern these industries. It updates the residential mortgage originator and servicer licensing agreement, which is in Statutes Chapter 58, initially passed in 1998, and the Mortgage Lending Authority has come from identifiable needs and pain points in the licensing and growth of the industry since the introduction of the SAFE Act. It also makes further updates to the approvals process for bank branch applications and expands the lending authority for banks who operate branches outside of the 4 contiguous states surrounding Minnesota. Mr. Kelly can also give another high-level explanation.
Mr. Kelly.
Mr. Chair and members, just given the time frame we are at, I think that Representative Kotyza-Witthuhn explained the bill pretty well. I'm happy to just stand for questions.
And are there any members of the public wishing to testify as to this bill? Seeing none, a member discussion to the bill. Seeing none, closing comments, Representative Kotyza-Witthuhn.
It's a good bill.
Representative Kotyza-Witthuhn renews her motion that House File 4041 as amended be recommended to be placed on the General Register. All those in favor say aye.
Aye.
Opposed? Motion prevails. And House File 4041 as amended is recommended to be placed on the General Register. The last bill on our agenda today is House File 4388 from Representative Urdahl. Thank you for your patience, Representative Urdahl. I will move House File 4388 be laid over for possible inclusion in an omnibus bill. Representative Urdahl, to your bill.
Thank you, Mr. Chair and members. This is a request by the Litchfield Baseball Association in the city of Litchfield to allow for strong beer over 3.2 to be sold at town ball baseball games in Litchfield. Now, for decades, they've been selling 3.2 beer, which I'm told is not intoxicating. Some people at St. Cloud State that differed with that opinion, but they have been selling 3.2 for decades. They got a temporary permit, which sets a precedence for this, for 12 days during the state baseball tournament last year, which was held partly in Litchfield. And so they were selling strong beer. We have been in touch with the city attorney of the city of Litchfield. They are in agreement with this language, and have also spoken with the school board superintendent, and they don't have any problems. To explain that a little bit more, this baseball field is located on property owned by the school, but it's 2 blocks away from the school. Again, beer is being sold there now. The ball field is leased and managed by the city of Litchfield, and there are few, if any, days when school would be in session when ball games are happening and beer would be served. So with that, I appreciate your support of allowing folks to drink strong beer at a baseball game. And I do have a couple of testifiers, and they'll take a couple minutes each.
Great. So we will start with Nick Ridgway. Mr. Ridgway, if you just want to come forward, state your name for the record and proceed your testimony. Welcome to the committee.
Thank you, Mr. Chairman, members. My name is Nick Ridgway. I live in Litchfield, Minnesota, and I thank you for taking this up. We were so excited last year when you passed the bill exempting town balls from teams from the 3-2 law. So you can imagine our disappointment when we found that we did not qualify that because the ground is actually owned by the school, even though it's a city-run ballpark. Like other teams, we struggled to find any distributors who would provide 3-2 beer for us. It's just really not sold anymore. And if it is, there's very few options, and especially with seltzers, which are very popular now. We've been, as Representative Urdahl said, we've been selling beer for for over 25 years at the stadium. We work closely with the city and the city attorney to get our license properly every year. And we just want to keep continuing to do that like other town ball teams. The city of Litchfield's in favor of this bill, and so is the school district. And I appreciate you considering it. Thank you.
Thank you. And we also have Ryan Jones. Mr. Jones, if you want to come forward, state your name for the record, proceed to your testimony. Welcome to the committee.
Mr. Chairman and members of the committee, thank you for having us. We, as you well know, we are the state of hockey, correct? But right behind it is baseball. Again, like I don't want to shatter a broken record, but last year we hosted the 100th anniversary of the state tourney. It's been around for a while, so it's pretty well organized, run very well by the state baseball association. We also had Fox 9 out there, and with both of those, we had over 30,000 people in our area. So it really is a big deal. And nowadays, I mean, I drink Busch Light, but I'm kind of a cheap guy. But craft beer is now the new thing, and a lot of people throughout Minnesota, including our community, we have a small brewery, and you know, people would come to the game, and you know, it's great family entertainment, but a beverage when it's 80 degrees out is not going to kill a guy, right? Well, they're asking for some of these summits and locally made Minnesota beers, and sometimes we're looking at it thinking, what is the actual regulation in that? And like Nick said, I don't want to shatter that record, but 3.2 is very, very hard to get anymore. More expensive, you know, taking away our bottom line. What we want to do is we want to get a product in there that people are happy with, along with our baseball product, of course, also. So that just helps us out a little bit. Again, our school and our city are both on board, and we've had plenty of years of serving it out there. Never had any issues with it. And I guess with that, I just want to kind of thank you guys and hope everything works out in favor of our direction.
Thank you.
I was pretty nervous, so thank you.
You did great. You did great. Didn't show. Mr. Jones, thank you.
Thank you.
Are there any members of the public wishing to testify as to this bill? Seeing none, we'll move to member discussion and questions to the bill. Representative Cleavorn.
Thank you, Mr. Chair, and Representative Urdahl. I totally appreciate where you're going with the legislation. Unfortunately, I have concerns about it because inherent in town ball, as was just discussed, is it's a family activity. And, you know, we've had to look at legislation even now in environments where no alcohol is served, protecting our referees and officials. And I'm just wondering if you have any thoughts about how inebriation will impact adult behavior at games, and then protecting family members who might be getting in a car with someone, even though we all know it's illegal now to drive while intoxicated. The harder the alcohol, the more likely the intensity of the inebriation. So I'm just curious if you have any comments about that.
Representative Urdahl.
Thank you, Mr. Chairman, Representative Claiborne. Well, first of all, if they were disruptive, they'd be removed from the ballpark. But that said, keep in mind that right now, strong beer is being served in ballparks all across Minnesota. This is one of the few places that still is stuck on 3.2. So, I mean, it's not been a big issue in the rest of the state, is what I'm saying.
Any follow-up, Representative Cleavorn?
Thank you, Mr. Chair. It's the situation that I'm concerned about is the legislature allowed an exception for the anniversary, and now here we are back asking for it to become permanent. And this is a school location, a property owned by a school district. So will we have other school districts coming in who may not have the 2-block grace that you have and asking us to do the same thing? And I'm just raising the concerns now, knowing that the legislation is being laid over.
I think I'm looking at Mr. Clayman. I think that what we did on Town Ball in 2022 was permanent, correct? It was not a temporary. It was a permanent
I stand
thing. It
corrected,
was not
thank you.
that wasn't temporary. But Representative Urdahl, I don't know if you have anything you wanted to add to that.
Well, thank you, Mr. Chair. And not really, again, we're just saying we would like to, well, Litchfield excels in many areas, but we would like to be like the rest of the state in this particular area.
Thank you. I appreciate the response. And I've just been a longtime advocate for children, so I'm just trying to make sure that we're doing our best by our kiddos. So thank you very much.
Let me just say.
Representative Urdahl, go ahead.
I'm reminded, I mean, there actually are other places in Minnesota that it's school property where they play baseball and sell beer. And again, I don't know if there'd be any games that would be played and selling beer when school is on. I mean, it's in the summer.
Representative Liebling.
Thank you, Mr. Chair, and Representative Urdahl, good to see you. Unlike my colleague, I don't have real concern about this in particular, and I suppose they'll be serving cheeseburgers along with this.
Yes, we do.
Okay.
We're going to Litchfield.
Yeah, well, I'm thinking that, I like to come over and I like Litchfield. But I was just going to ask you, you're not going to have 17-year-olds serving alcohol, are
Representative Urdahl, I don't know if you.
Mr. Chairman, no.
Thank you, Representative Urdahl. Unless it's legal. Representative Bierman.
Thank you, Mr. Chair. Thank you, Representative Urdahl, for the bill. I think you've done your due diligence. I think with your community members down here testifying, I appreciate that. I appreciated the tour in Litchfield. I know exactly what a lovely city it is, and the centerpiece that you showed me that you knew I'd be interested in. So I think you guys can handle it, and if you don't, we'll be watching. Thanks.
There you go. Representative O'Driscoll.
Just to underscore a couple things here, this is a joint facility or a common facility that the school and the community uses, and it happens to be on school property. So I appreciate, the conservative use of local resources. The only question that I want to bring forward on this is, you may want to check with MDE, and you may want to check with the Minnesota State High School League just to get letters of clearance from them. This is not a commerce, this is not a state of Minnesota specific regulation. It is MDE that says you can't do these kinds of things. So you may want to run it by them administratively. Otherwise, your bill, the liquor bill, if this is included, may have a trip to the Education Committee as well.
All right. And Representative Urdahl, you're welcome to respond to Representative Driscoll and then also closing comments, please.
Thank you, Mr. Chairman. And Representative Driscoll, I remind you again that this facility is leased and managed by the city of Litchfield, not the school district. But, we could take, under consideration your suggestions to talk to the High School League, Department of Education. I frankly don't foresee any problems with that. But one thing, Mr. Jones, would you tell them how good a softball player I was?
Mr. Jones, you're not under oath, but
Mr. Chair, are we not out of committee time at this point?
I do swear. He's still playing. He's actually on our team. Yes.
All right, wonderful. And with that, the bill is laid over, and with no more items on the agenda, the meeting is adjourned.